Hi guys, it's Lisa from Been There, Got Out, and today's guest hasn't been on for like 3 years, and I think a lot of you know him. His name is Judge Anthony Bompiani. He's a retired judge and family court lawyer. There he is, from Penn. Anthony, I just invited you. Let's see if this works. But it's been a while, and we share a lot of the same community, which is people dealing with really different. Hi, it's been so
Hey,
long.
I know. How you been?
Good. How about you?
I'm good. Yeah, I'm good. I'm out in Arizona, so it's 8 a.m. right now, so bear with me a little bit.
Thank you. Thank you for waking up early to do this.
Yeah, no, thank you for being flexible. I know we had it initially scheduled for noon Eastern, and then I had something come up I couldn't move, so I appreciate you being flexible. It means a lot.
Yeah, no problem. Anytime. So today I wanted to talk about presentation, but I wonder if you hear the same thing that I do a lot, where people say, my facts were perfect. All my evidence was there and I lost the case. Like, how did that happen?
Yeah, I do hear that a lot. And what
Actually, Anthony, before you even, why don't you first introduce yourself officially and then answer
Yeah,
the
yeah,
question?
yeah, sure. My name's Anthony Bompiani. I go by Judge Anthony online. I'm a retired judge, a family law attorney. I still maintain my practice. I don't really practice anymore. I do more consulting with people all around the country and in different countries actually. Um, I'm initially from Pittsburgh, and now I fly back and forth every other week from Arizona to Pittsburgh because my fiance and I live out in Arizona, and my kids live out in Pittsburgh, and I do week on, week off with my ex. So that's me in a nutshell.
Yeah. Okay. So again, like, thanks for coming
Yeah,
on. I was saying before you popped on, we do similar, but of course I'm not an attorney and certainly not a judge. But being a judge and being an attorney, and you hear someone in a situation who's like, the judge is biased because my evidence was perfect.
yeah.
In my mind, I'm thinking there's a couple of issues, but probably presentation is a big part of it. So can you talk about like how that happens from your
Yeah,
perspective?
yeah,
Why that happens?
yeah. First off, I want to say that people need to understand that happens with attorneys too, right? I mean, when I was practicing law, I would go into cases and I would think that I had an incredibly strong case. In family court, I also did a lot of criminal defense work too, and I can remember going into cases and thinking that my case was really strong, and then not necessarily getting what I want. So people need to understand that that's not just, it's not necessarily a personal bias against the person. Sometimes like the problem with court is there are so many variables. Like there's so many variables in court. Like each jurisdiction's different. Each judge is different. Each judge can view something different on a particular day, right? Like there's so many different things that happen. Sometimes you're very poor in your presentation of the facts. Sometimes a witness that you have is very poor in the presentation of the facts. Sometimes you have a piece of physical evidence that you think's a slam dunk and doesn't get admitted or doesn't even get looked at by the judge for evidentiary reasons, right? Or sometimes because the judge is not smart, doesn't know what the rules are. Sometimes judges are biased, right? There are so many variables that it can never be, 100% concrete. That's what I even say. Like the stuff that I teach is very impactful, very effective, and very good. It's things that I've used to win cases throughout my career, but it's never 100%.
Yeah, and that's actually a red flag that we mentioned in our book and in general is that any lawyer that said this is a slam dunk case, you have to be wary of because of the variables that you mentioned.
Yeah, 100%. And also, what I'd like to add to that I like to tell people is a mindset tweak that you can have, especially in a divorce or custody case where it's not like your final hearing, right? Say you go into a argument court or motions court or some beginning stages and you lose, right? Or you lose or you get an unfavorable decision. Well, what I always say is the difference between a great attorney, a good attorney, and a non-attorney in a case is that a non-attorney will take that loss or that unfavorable decision and almost take it personal and almost either take it personal or throw their hands in the air like I'm done, I can't, this is over. A great attorney will take that first loss and figure out why. Like, what did the judge bite on that the other side had? what did the other side have against me that I can mitigate moving forward in the next hearing or between now and the next hearing? What was the judge taking notes on that seemed rather important that I can now add information to? That little mindset tweak, like I said, it's the difference between a good attorney and a great attorney. And that great attorney mindset will get better results as the case goes on, 9 times out of 10.
Yeah, it's like focusing on what can I do
Mm-hmm.
better instead of just blaming and giving up and thinking that there's things that you have no control over. Yes, it takes a lot of tenacity to go back, and it does always feel like a gut punch.
Yeah.
But
And
if
it's
you give up, then you lose.
100%. And I get it. Like, look, it's not like I say it like it's easy. It's not easy because the things that people are going through are the most important, most emotional things that are happening in their life. Like, it is a number one. It's either your kids and or the destruction of your relationship and trying to figure out how the hell you're going to move forward. So it's certainly not easy, but if you can do it, you're going to increase your chances as the case goes on.
Yeah, for sure. So we got a question a little bit ago. Somebody asked about how strong audio files are in terms of evidence. We get this question a lot in terms of videos,
Yeah.
and I'm thinking about AI and the impact it's had from people that we've spoken to, especially in the field of
Yeah.
cybersecurity. Just from what you know, how strong do you think, let's say, an audio confession is? I think that's what she had mentioned.
Audio confession, if you do it the right way and if it matches the rules of evidence and is admissible per your rules of evidence and laws, it can be very effective, depending on if it's one little tiny snippet, right? Sometimes people like to take a full conversation and give one little tiny snippet without context to try to like bury the person or try to show the truth. And that isn't always impactful because it opens the door for the other lawyer to make arguments like maybe even to keep it out, and or if it's not kept out and the judge hears it, to make arguments like it's not the full recording, it's not the full conversation, it doesn't have full context. Let me add testimony from my client to kind of like paint the picture of the full context. But that being said, sometimes you don't even get to that point because the one thing that people need to consider is that in a lot of different states they're either a one party state or a two-party state. So if you're a two-party state, you have to do your research. It's real easy. Like for Pennsylvania, I'd say in Google, is Pennsylvania a one party or two-party state for audio recordings? If you're a two-party state, you have to have consent of both parties to be recorded, right? Now, sometimes that doesn't mean like verbal active consent. Sometimes that can be a voicemail because the theory is that if somebody leaves a voicemail, they know that they're being recorded, right?
Oh,
or
interesting.
yeah, or like on a ring that person set up in their own house, right? I would argue that they gave consent when they set up that ring and when they were on there talking freely, right? um, if you're a one party state, then you only need the consent of the recording party to take the information and then to try to present it in court. So I hope that kind of paints the big picture of audio evidence.
Yeah, yeah. Thank you.
Mhm.
The what you mentioned too about it being just a little clip, like that we always talk about how it's important to establish patterns of behavior over time. So sometimes people be like, I got this one thing and this is what's going to win. But like you said, and what we know too, is that it's not enough. Like it could be
Yeah,
something like maybe one thing, but a lot of times it's the history of what's been going
yeah,
on.
100%. And two, you have to relate it back to the issue at hand. So if it's custody, you have to relate it back to the best interest of the child and whatever laws are there for the best interest of the child. If it's regarding divorce, you have to relate it back to a financial issue of divorce, grounds for divorce, alimony, division of property, whatever it is. And people need to understand too that like a lot of times that stuff gets overlooked, and the reason why is because if you're going into a hearing in family court for whether it be for divorce and or custody, that judge already knows that you're in a tumultuous relationship, right? That judge already knows you guys are going to be arguing, you're going to be fighting, you're going to be saying things that you don't mean, right? That's why sometimes these things that happen, you know, maybe there is a history of abuse, and that's so sad and unfortunate. But if you only have one little snippet and you can't back it up with other credible evidence, it's going to be very difficult to get it to a point where it's relevant and persuasive for your case. because, like I said, you have different evidentiary issues you have to overcome. You have to relate it back to the best interest of the child or the issues in the property. And you have to show that it's more than just one little fight, one little conversation, right? That it's this person's, you know, character or penchant to do this, or, psychological issue or drug and alcohol issue. And then that's where different experts come in.
Yeah. And so I'm really glad, and I always am a note taker. So as you're talking, I'm like, oh, another question that
Yeah,
I'm thinking of
yeah,
myself. In terms of evidence, people often say, well, it hasn't happened yet, but I know it's going to happen.
yeah,
And
yeah,
we've heard that that's not usually enough to get something, let's say, written into a parenting plan.
yeah,
Like, for example, alcohol testing.
yeah,
Did the person get a DUI? Is there any like long pattern of behavior that you can prove? Well, no, but I know they've had a
yeah,
drinking problem. Can you
yeah.
talk about that? How people get their hopes up thinking I'm going to ask for something when there's really no evidence trail to show why they're entitled to it.
Yeah, I'll talk about that on two levels. I'll talk about it on the evidentiary side of things, and then I'll also talk about it on the internal side of things, right? Number one, on the evidentiary side of things, when you have that, like, it didn't happen yet, but it's going to happen. If you're in a hearing and you're in a hearing in a court where the court follows the rules of evidence, in particular in the United States, that's that's speculation. That's speculation under the rules of evidence. And if I were the attorney on the other side and you even started to testify about something like that, I would object that it was speculation. And if the judge is following the rules of evidence, they wouldn't even let you talk about it. So to include it in a negotiation, like a mediation or conciliation or something like that, it's not going to be as impactful because that other attorney knows if you go forward through a hearing, you're not going to be able to use it anyway, right?
Mm.
And then from an internal side, like mindset side, I always tell people, like, what's already happened is enough turmoil to, like, ruin your day or ruin your situation or to have to deal with, right? Let's not add, like, it's okay to plan for things, but let's not, like, add and stack on top of what you're already presently going through, what you could be going through in the future, right? Let's plan for it and let's be mindful of it, but you got to take that into consideration as well.
Yeah. What are some other mistakes that you see commonly happen when people go into court who are obviously really emotional, like with custody battles, where like, this is what I think is going to happen, and it doesn't?
You mean as far as, like, why that happens?
Well, I'm thinking not why, but like what specific mistakes do people make? Like, for example, I'm thinking one thing we see more than anything is somebody's like, I'm going to go into court and I've got like binders of evidence. And so
Yeah,
what I'm going to do is I'm going to make the judge
yeah,
understand what happened to me, and then they're going to punish, and I'm going to have hours that the judge is going to listen to me. So I know
yeah.
that's a myth. So I want you to say why.
Yeah, I mean, you got to be like, that does happen a lot, and you got to be realistic, and you have to understand, that there are specific evidence rules and timing. Like, time. I know I've had people come to me and be like, I've planned for this hearing, and I got like 5 minutes to
Right.
speak, right, or 10 minutes to speak. So you have to understand that, number one, everything that, like, I think in preparing for that situation, or the best way to prepare for that situation, is that when you're leading up to it, to, number one, prepare your evidence in a way that it is only evidence that, like I referred to just a little bit ago, that's in the best interest of the child. If it's a custody case, or the factors of custody that the judge looks at, or whatever the judge looks at to decide custody, that evidence, that it's not just evidence that you want to show that your ex is a bad person or a jerk or a narcissist or abusive. You have to be able to relate that evidence back to the best interest of the child. So that's number one. I would bet that a lot of people listening to this live, I know a lot of people that I've worked with, that, like, cuts down a lot of your evidence right out of the gate, right? And you say, some people say, well, why should that happen? Why? Like, that's actually a good thing, because if you can get lasered in and focused in on only the information that is going to help this judge make the decision one way or another based on the laws in your state, that's the way to do it, right? And you can't just you can't, like, you can't turn it in. A lot of times when people are going through this, they're obviously in a lot of pain, and a lot of times that pain is caused by the other side. But you can't fall into the trap that you want to use the court to to inflict the same pain you're going through on the other side.
Mm.
That's not you're gonna like. I know it feels good and sounds good, and like I get why people want to do it. It's a natural human reaction, but it's not gonna help you win. It's not gonna like. I've had people say like to me when I'm consulting them like, well, I want to present this because I want to set the record straight.
Mm.
I'm like, you don't want to you can't focus on setting the record straight. Focus on winning your case. Like focus on showing the judge what's going to move the needle in your case, whether it be for division of property or alimony or health insurance or child custody or parenting time. It has to be something that's related back. I know that was kind of long-winded, but I hope that answers the
No,
question.
no, it's funny, but of course I have three things I want to say
Yeah.
that are different. Starting with the last thing you said about focus on winning your case. That's the thing that we say to our clients too. We often get people who say they're in the middle of their own high conflict case and they'll say, I'm really interested in changing the laws and helping other people helping other people who are going through this. Like I want to change the laws and do advocacy work. And so my partner Chris has a sign that he holds up of a cartoon from The Simpsons, and he says, "Let other people carry the torches and pitchforks for now. You got to win your case.
Yeah.
You only have so much energy." Like, and that's actually a trauma response. We've heard from Caroline Strawson, who's like an expert on this sort of thing in the UK. But she said it's a trauma response because it's so hard for us to deal with our own issue that we want to focus on someone else. It's almost
Mm,
like codependency. Like I'll deal with somebody else's
interesting.
problems, but I can't focus on my own. So that's the first thing I want to say. The second thing, when you were talking about documentation, we call it targeted documentation.
Mm-hmm.
So it's like you have to understand if, because our clients, we only deal with high conflict. So all of
Mm-hmm.
our clients are dealing with some kind of domestic abuse, and they'll often, in a custody case, blend the abuse with the custody. And we have to always say it's separate. It's the restraining order is a separate issue unless your children are part of it. So you have to make a different kind of argument.
100%.
The third thing, and now I'm doing all the talking,
No, you're fine.
is that when we talk about, when you said you only have, putting something together and that somebody comes in with barrels of evidence, you say, I only have like 5 minutes to speak. We often say it's like you're paying $6 million for a 5-minute Super Bowl commercial. You have to be laser
Yep.
focused on stuff the judge cares about. You have to do something called front loading, which is like get out the most important information first
Yep.
and let the judge know this is what we're going to, I mean, I'm doing a lot pro se, thinking of pro
Yeah,
ses,
yeah,
but obviously
yeah.
many of our clients have attorneys, but you want that to get out there first. And I remember, Judge Anthony, you said in one of your videos a while ago, like the judge remembers what you say first
Yeah.
best and what you
Yeah.
say last.
Yeah.
Do you remember that?
Yeah, sure. When I was in law school in trial advocacy class, it's something that I learned that I carried through my career, both in arguing to a judge and even more in particular, presenting cases to a jury. And it's a persuasion tool. And what it is that, and this is not just in court, this is like in sales and in anything. What someone hears first, they remember best. And what someone hears last, they remember first. So what I instruct people to do is use that the whole way through your case. It's like not only in what your testimony is, but the testimony of your witnesses. And you can narrow it down to the order of your witnesses, right?
Mm-hmm.
The order, the person they hear first, they're going to remember best, and the witness they hear last, they're going to remember first. So if you're trying to decide an order of witness, that's a wonderful way to do it. It's why, excuse me, it's why when I was practicing full time, I would either call my client first or last because the client is going to have the most important things to say. So you either want the client's words to be heard first so that they're remembered best, or that they're remembered or they come last so that they're remembered first. And like I said, that's not just court. That's in sales. That's in, if you're trying to help one of your kids through something, or you're talking to your spouse or whatever. Like that's just a persuasion tool that's very impactful. And it's like you said, front load it. Front loading's really good, right? But you want to circle back then at the end to hit an important point.
Yeah. So I don't don't know if you know this, but I used to be a high school English teacher, and I'm also a professional writer. So we always talk about the hook.
Yeah.
You need to get the hook
Yeah.
at the beginning, and then you need to have a powerful ending. So it's just,
Yes.
again, it's the same technique. It's not just court stuff. It's in
Yeah.
general. You want to capture someone's attention.
Yes.
So speaking of that, as a judge, being on both sides of the bench, can you think of things, and it doesn't just have to be in family court, but what are ways that someone can present where they really capture the judge's attention?
Yeah. Well, the way I do it, and I have different tools available for people. One of them is basically a trial preparation planner, right? And one of the things that I teach is that the first thing you want to do, and this is what I did throughout my entire career, is you want to create a simple narrative of your case based on your laws. So, like I said, if it's divorce, it's going to be the laws that are impactful on the alimony, the child support, or not child support, the alimony, the division of property, the health insurance, whatever the issues are, grounds for divorce. If it's custody, it's the law and the factors or the case law that the judge follows. So you zero in on those rules, then you come up with this very short, maybe 4 to 5 sentence narrative of your case, right? You have that narrative at the very top of your page, and now you start to break that down into other issues of your case, right? And then from those issues, you're now going to fill in witnesses for each issue and physical evidence for each issue. So then you have this like mind map or brain map or whatever for your case. And then you know that everything that happens in that case, whether it be your presentation of your evidence, presentation of the witness, the testimony of your witnesses, cross examination of the other side's witnesses, you always relate back to that narrative, right? It might be that, it might be something as simple as, dad's work schedule and travel schedule and distance away from the child's school and mom's house isn't conducive to 50-50 custody, right? Or, something like that, something as simple as that. And then everything you go in the case to show are on those particular issues, right? And if you can keep it succinct like that, then you're going to have an easier time of grabbing the judge's attention and getting them to zero in on the things that they are going to actually look for or supposed to look for based on the law, rather than being like, well, 10 years ago we met and we started and we did this and we did that
And
and we
how
started
often do
and
you
then
do?
he did that and he did this. And I get it. Like, I'm not putting people down for doing that, because again, even like the divorces that aren't high conflict or don't like involve abuse, they're still like traumatic. They still suck. They're still traumatic. Regular people aren't used to going through that stuff. I always say, like, I went through hundreds of divorces before I went through mine, and mine still sucked. Like, so it's not like it's something that it's not like I don't expect people to just know this. It's something they have to practice at. It's something they have to get good at, right? Invariably, it happens on my consulting calls, right? They'll go into a big line of things. Usually, I let them go a little bit because I know people have to get that out, right? They got to get it out. But when you're in court, man, you don't want to do that, because you're gonna see the judge probably like writing something or thinking about, like, and that's just human nature. And you have to know that. So you got to keep that narrative succinct. You got to hit them with things that matter right out of the gate, and you got to say words and show evidence that helps make the decision based on the law.
Yeah. And I think it's so important because it provides structure and organization. And the
Yes.
people that we deal with all the time, that you deal with a lot of the time, are traumatized. And a number of them also have ADHD,
Mm-hmm.
whether it's from, the anxiety of what they're dealing with. And so they tend to be all over the
Yep.
place. And so by having like a simple structure, and again, this relates so much to me with being a writer, it helps organize your thoughts and your evidence. Because how often do we both talk to people, like you said, they come in and I say, okay, what's your plan? They're like, I don't know, I just want to say this, this, this. I'm like, okay, but let's first figure out what you are
Yep.
asking for. What is the goal? Like, you haven't even thought about it
Yep.
because you're so scattered, which again is completely normal for
100%.
people who have never gone through it before. So to say, let's start out with that first paragraph, and that's we call it like an opening.
Mm-hmm.
That paragraph of like, Your Honor, like, this is what I'm asking for, and this is why I'm entitled to it, and have case law and evidence. And that's the intro. And then the rest of it, like you said, goes through point by point and always ties it back to those issues. So I
100%.
think having that structure, like, anybody can use, a writer, but especially someone in court, because it also helps calm people down. We
Yes.
say that our role with our clients is to help them be calm, not by saying calm down, because that's inflammatory,
Mm-hmm.
but by helping them stay focused
Yep.
and organized. So when you have something you've already written out that you can keep going through, most of the time people realize they know more than they think they do. So they don't need to think about memorizing facts. It's their
Yep.
lives. So they have that. They just have to be able to bring it, to trot it out
Yeah.
in an organized fashion, and emotion gets in the way. So
Absolutely. Yeah.
yeah, so I love what you're doing with that.
It's
It's so similar.
Yeah, no, I appreciate that. It's very difficult for someone who's pro se to do it, especially during their testimony. But what will help is if you think about how a good lawyer, not just a lawyer, but a good lawyer will have you testify. They're not going to put you on the stand and be like, all right, Lisa, tell me what's going on. They're going to be like, state your name for the record. Where do you live? Who do you live with? Where do you work? What are your hours? Like they're going to go through like question fact by fact by fact and then transition into an issue into the case and then go fact by fact by fact and transition into an issue. And that's the same model you want to use whenever you're trying to either argue or testify to the judge.
Yeah, as you say that, I'm thinking about, and I always say I'm not an attorney, but I've been to court like 100 times ish in these past few years, especially as self-represented litigant. But what you're saying makes me think of cross-examination, because basically the questions you ask tell the story, and you want to ask questions that have very limited answers from the person you're
Yep.
questioning, so that you can get your story out to the judge. You can't tell the story unless you're being questioned. So it's really tricky.
Yes.
And it took me a while to learn, because I would ask like very leading, like I'd give like narrative questions. Judges like, you can't do that.
Yeah.
So just little bit by little bit, for my ex in particular, to say yes, no, and prove the case like that.
Yeah.
That's another way to organize your thoughts. You can't say, but he's lying or she's lying. You have to ask the question
Yeah.
and have the piece about, do you see
Yeah.
this? Did you say this? Did you just say that before? Okay,
Yeah.
that's it.
Yeah.
That's it.
Yeah. For
And then the other,
cross-examination. Go ahead. I'm
yeah,
sorry.
no, I was going to say, and so much of it involves, and this has been so hard for me, like restraining ourselves and letting the judge form his or her own conclusion.
What do you mean?
Well, I know
Oh,
sometimes and our clients do, is like, I know, and I want to tell the judge that this is what it is, but you can't do that in cross-examination. You have
right.
to have the
100%.
questions lead to answers where the judge can form their own conclusion.
100%. Yeah. You don't, for cross-examination, just to try to keep it simple for pro se people who are trying to do cross-examination, number one, you always do leading questions. You always do leading questions. You never ask open-ended questions.
Give like an example. Just, I mean, I know, but just give an
Um,
example quickly.
Yeah, there was a video that I did a while back when I was wearing like a black Adidas track jacket, and I gave the example like if I had a witness on the stand trying to get them to testify to this track jacket, I wouldn't say what color is the track jacket.
Okay.
I would say this track jacket is black and it's Adidas, isn't it? That's leading, right? It gives them the answer, right? Now,
Yeah.
that's number one. Always ask leading questions. That goes to number two, is if you're going to be asking these leading questions, you got to understand they're not always going to answer the way that you want. So you have to have the evidence and the facts that will force them to answer the way that you want. And if they don't, then they're going to look like they're lying. Let me give you an example. It doesn't mean if I say the track jacket is black, isn't it? Or the track jacket is black, right? Or the track jacket is black, isn't it? If they say no, then my ass better have a picture of the track jacket, the actual track jacket, or a witness that's going to testify in rebuttal to the color of the track jacket. I'm not going to say, no, it isn't. It's black. No, it's blue. No, it's black. No, it's
Because
blue.
you
No, it's
can't.
black.
You
Yeah, the
can't.
judge is going to like kick you both out, right?
Right.
So you pin them down to the answer, and then you walk over, you grab your picture, your physical evidence, you walk over to give a copy to the counsel, you give a copy to the employee for the judge, And then you ask to approach the witness. You show them the picture. You see this picture. Yes, it is. What is it? It's a picture of the track jacket. What color is the track jacket? Oh, it's black, right? That's how it's done. And then number three is you never ask a question on cross-examination that you don't know the answer to.
Mhm.
You never, ever, ever do that. I guess the only caveat I can say from my career is that the only time I ever did that was that as if that I was so curious that I wanted to hear what the answer was because I thought it could lead into other information, right? But that's a little too complicated.
Mhm.
I would stick to the rule that you never ask the question you don't know the answer to. And the example that I learned in law school was a guy in a criminal case, and this is a real case, bit off the ear of another guy. And the cross-examination questions were, you didn't you didn't see him bite the guy's ear, did you? There's the thumbs up. You didn't see him bite the guy's ear, did you? No, you didn't see you didn't see him walk over to the guy. No. In a good cross examination, you'd stop right there. But what the attorney did, they said, well, then how did you know he bit off the guy's ear? And the answer was because I saw him spit it out. So that's a disgusting example, but it's one that resonates with me. Obviously, I've remembered that for about 25 years, but you never ask that conclusion, like conclusory conclusion question or the question you don't know the answer to. You would save that in that example, you would save that question for your argument, right? If you cut it off that you didn't see him bite off his ear, did you? No, you cut it off, and then in your closing argument or in your briefs, the witness clearly testified he did not see, the person bite off the guy's ear, so therefore he could not know if he bit off his ear, right? That's an example of how asking the question you don't know the answer to, or asking that conclusion question, is good. Because let's be honest, you ask that conclusion question or the question you don't know the answer to, they're going to give you the answer you don't want.
Right. Right. All right. So of course, as you're saying this before the part about the ear that completely distracted me because I'm very visual and picturing
Sorry.
like discussing this. That's okay. I was thinking about, asking those kinds of questions. I'm thinking back to my own, one of our hearings a couple of years ago, which was financial. And I made the mistake of spending time going through my ex's financial affidavits with him. And you could see the judge's body language, which, she wasn't interested. She was getting tired. She was looking at the clock. And so I had to quickly pivot, which is another thing that happens during presentation is like, oh, I got to stop what I'm doing because it's annoying the judge or she's not paying attention. And so I realized that I better start getting to what we needed to get to because it was getting late in the day. So one thing I did with cross-examination was I would say, it was a college issue. I just said, we haven't paid these, I don't have this money. Like my motion was to get this money back. So I went through and I asked my ex, have you paid this particular bill, like for our daughter's book? He said, I don't know. And then I said, do you have verifiable proof that you paid? No. So we just went through like that. And that basically, I think, was the win for the entire case.
Awesome.
Cut time with something the judge was interested in. And there was no emotion.
Yep.
It was just like, did you do it or not? In the past, my early pro se days, I would have been like, but you didn't, and that wouldn't have been allowed.
Yeah.
And I would have gotten
100%.
emotional.
100%. You're 100% right. And that's like one of the things that I teach is about getting into the mind of the judge, right? And again, it's not just in court, it's in sales, it's in like talking to your spouse, it's finding out what's important to them, right? So in court, what the very first time you ever step foot in that courtroom and you're in front of that judge, you should be observing, even if it's not in your case, even if you're back sitting in the back while another case is going on, you should be observing what that judge latches onto and what is important to that judge. Not so like I've had people say like, well, then you're manipulating as well. Not that you're going to lie to the judge, you're going to make sure that that evidence that you have is going to be handed to that judge because it's something that's important to them, right? So it's just what you did in the middle of the case. You realized that what you were saying was not impactful. The judge was getting frustrated. You have to be aware of that stuff so that then you can pivot to do exactly what you did. So kudos to you for sure.
That
That's
is
good.
took a lot of practice. So this was
Yeah, and
many court
patience
appointments,
too. Yeah,
right? Yeah. So we just got a question that is the perfect question to ask you is how important is a judge's body language? I know that we teach, like, when you're there on the stand, don't look at opposing counsel, you look at the judge.
yeah,
You're talking to the judge, even though you're answering that person's question. And if you get into an argument with opposing counsel as they're baiting you to freak out,
yep,
you're actually talking to the judge. So always remember that.
yep.
So why is it so important? Or tell us about judge's body language or
Yeah,
what things
well,
mean.
yeah, well, number one, the judge's body language is incredibly important. As a lawyer, throughout my career, I paid attention to that immensely. Same with juries, right? It's very rare in the United States that family court has any juries. Some states do, but anybody who's the finder of fact. So in a case in front of a judge, the judge is the finder of fact. The judge is going to be deciding what's fact and what's not. In a case in front of a jury, the jury is a finder of fact. So if you're in a case with just the judge and no jury, the judge is the finder of fact. So when you're sitting on the stand, or in Zoom, and the attorney's asking you questions, the appropriate thing to do would be to at least, maybe not turn the full way to the judge, but at least like turn more in that direction to answer your questions to the judge, because that's who's deciding the case. That's who's deciding what the facts are, right? And if you're in a case with the jury, you would turn to the jury. You would turn to the jury and answer your questions, right? And it's the same in it's more difficult in cross examination because usually you're flustered and the attorney got under your skin and you're
Mhm.
angry, but it's the same theory. Now, as far as the body language goes, 100%. I did that like throughout my career. Like I said, not only in my cases, but in cases that would be going on before me, to try to see where the judge was getting frustrated, what the judge was latching on to, what was important, and during your case, if you can find that out, then you can keep adding facts to what's important. Like if you see the judge like sit up, I've seen like judges like where my client would say something that the other side did, and the judge like turn and like glare at the other side, right? Because it's
Right.
something
I
like
love
very,
that.
yeah, like something important. So then you know that like you keep hitting it, right? Or again, like you did, if it's body language that shows a disinterest or frustration, then you start to pivot and backpedal a little bit.
Yeah. One of the judges who's like the head judge in one of the courts I was in, she kept a mask for, I mean, not an actual mask during COVID, though we were there for that, but she would take this very neutral expression and she would smile and nod her head. And it was so frustrating because I was like, is she being sympathetic to the other side? But she did it for everyone. But it was like very powerful because she didn't reveal
Yeah,
what she felt. And
yeah,
reading books about power, I'm like, that was deliberate,
yeah,
like just done deliberately. Like she
yeah,
wouldn't show how she felt.
yeah. And you know what? I'll add on to that too, because when you just mentioned that, it made me think another thing that's important too is not only the judge's body language, but their law clerk's body language, their
Ooh.
security's body language. And let me tell you why, because you know, being a judge, and also when I was in law school and just coming out of law school, I worked for judges. So I did law clerk work for judges. And when there's a break in the case or the case is over and they go back, the judge is going to kick the case around with the law clerk. That's what they do. Like that's what the law clerk's there for, is to help them research the law and to like they kick the case around. So if you see that the law clerk is interested in something, that's a good sign too, right? That's something to be mindful of, because you think it from a human being perspective. That's what we do at our place of work, and that's what the judge relies on the law clerk sometimes for facts that they've missed, facts that maybe the law clerk picked up on that are related to the law. So that's a little important thing to do too.
Oh, I love that. I've never thought of
Yeah.
that before. And of course, you're making me remember times that the stenographer would look at me when my ex, who did not do very well presenting in court, she would roll her eyes. And I just, even though I felt like she didn't have any impact on the case, it made me feel so validated.
Yeah, yeah. It's like if you're a salesperson and you're going into a business to sell them something, right? You're not going to be a jerk to the person that works the front desk.
Right.
right? Because like if you're trying to sell something, that person's going to be like, man, that guy was a jerk or an a-hole or like whatever. It's the same thing in court. Not like, look, they're still supposed to, and hopefully they do apply the facts to the law, right? And that's what matters. But they're relying on that person for research, for picking up on facts that they didn't know about. So it's important that you have a good impression on them as well.
Yeah. Yeah, and this is why it's so important to talk about presentation, that it's not even just to a judge, it's the periphery, it's the other people that are there,
Yep,
and they like
100%.
I know I don't remember where I either read it or learned it, but how important it is also to treat people who work at the court
Yeah.
respectfully, because they're colleagues.
100%. That's one of the things that I teach in my program with communication with the court is like, for example, when I like, obviously like for an attorney, if you practice in one county specifically, everybody pretty much knows you, knows your character, knows who you are. So it's not as obviously to maintain that character, it's important. But for example, when I would go into other counties and represent people, and if I was in a county for the first time and didn't know anybody, they didn't know me, literally from the time that I stepped out of my car in the garage, anybody that I saw, I would smile at, I would talk to, I would go through the security, I would talk to the sheriffs at the security, ask them any questions I want. How's their day going? Should I put this stuff right here? How are you today? Oh, crack a joke when you're walking through.
Yeah.
Oh my gosh, like I don't like just to really get a rapport with every single person that you see in the courtroom because not only is it helpful from a discussion perspective when people are talking together about you and your case, but also it like creates an energy, right? It creates an
Yeah.
energy of professionalism. It creates an energy of like, this for from an attorney's perspective, this person has their crap together. Like this person like is professional. They know what they're doing. So, it, it always served me well doing that. I could always like, in criminal cases, I can remember in particular when I would go to other counties to represent criminal defendants and say that I would be on a jury trial for like 3 or 4 days. That first day, no one knew who the heck that I was other than from like being there for like motions court or whatever. But by that fourth day, man, like they knew who I was. Like they knew that I was like professional. Like I knew what I was doing, and it's important from a party standpoint too. I can guarantee it.
Oh, totally. Again, like this is something I never thought about, but being in two courts, one in particular for years, I got to know the security guards, I got to know the
Mm-hmm.
bailiffs, and it felt really good because they'd
Mm-hmm.
be like, "Oh, you're still doing it," and but they would express sympathy, they would express support, they would ask what they could help, and it did put out some really positive energy. And
100%.
even though I was horribly scared, it just felt like there was this invisible support
Yep.
just from having that interaction with the same people for
Yep.
years.
Yes. Yeah. Absolutely.
Yeah, but I'm so glad you mentioned that. All right, so any other last minute tips for people who are dealing with these highly emotional cases
Yeah.
that they should know about either in and out of court? Because this is, I love, again, I love that you mentioned the stuff that's not just in front of the judge, because I think it does matter.
Yeah. Definitely. I think the biggest thing is, and I've said this from the beginning when I started doing this. The biggest thing in these cases, it's not even something that happens in court. It's what happens out of court, and in fact, it's not even what happens in your surrounding circumstances. It's what happens up here and right here in your mind and your heart. And you're like these, like I said, my case, like I was through hundreds of divorces before. My case never even went to court. My ex and I actually, as far as divorces go, was actually like fairly friendly. The beginning, like, was dramatic, and we said things back and forth that we probably didn't mean, and it got tense. My point is even me, the person who was probably most prepared to go through a divorce, like in the world, right? It sucked and it really hurt me and it really like destroyed me physically and mentally and
Mhm.
emotionally. And what I started to do and what I really urge everybody to do is to really, really, truly take care of themselves first. Like the best revenge, if you want to get revenge, if you're in like an abusive situation or a high conflict situation situation with someone who's narcissistic or toxic, which I was not in any of those. But if you really want to get back at that person and you really want to serve your kids, take care of yourself first, right? Like do like I always talk about the FML method, right? Focus on your fitness and your faith, focus on your mindset, and focus on love and relationships with other people in your life who actually care about you and who actually give a crap about you. And there's a healing process that you have to go through. And if you don't complete that process, nothing that you do in court or no result that you do in court is going to mean anything because you're still going to be stuck in that place. So that's the most important thing for sure.
Yeah, and I think finding the right support, people who really get it and can help. We always talk
Absolutely.
about the team approach, and
Absolutely.
keeping in mind, people often say, like, my friends and family, I've been isolated, my
Yeah.
family doesn't get it. There's a lot of people
Yeah.
who do,
Yeah.
and keep it, and remember too that many people in these situations do come from toxic families of origins. You shouldn't expect that
Yes.
from your family, but you can find it elsewhere.
Yes.
People who have been isolated in relationships, like this is really, really common. It
Yep.
often feels like you're the only one who's isolated and everyone else has friends. It's not true.
Yep.
It's not true. That's
100%.
a logical consequence of coercive control. But there are communities like yours, like ours, for people to really get help
Yes.
to move through this very difficult process. Like we often talk about how neither of us can make it end faster, but we can
Hmm.
help get them through it, hopefully as unscathed as
Yeah,
possible.
absolutely. Yeah, I always say that a divorce is the perfect litmus test for friendship. So it's like the line
Yeah.
in the sand, and you know, sometimes it's addition by subtraction. So,
Mm.
you gotta remember that you're losing people in your life. Maybe it's for the best because if they're not supporting you, and you don't have to be vindictive towards them or resentful towards them, but that, it goes back to focusing on yourself and focusing on healing yourself. So,
Yeah. So, Judge Anthony, how can people find you?
yeah, I mean, here on Instagram, it's Anthony Bompiani. On TikTok, it's Judge Anthony. JudgeAnthony.com is my website. I have a lot of different resources, some free, some paid. So yeah, check it out. Be glad to help anybody for sure.
Yeah. Well, thank you so much for taking the time.
Absolutely. Thanks for
And
having me. I
this is
appreciate it.
excellent.
Yep.
All
Thank
right. I'll
you.
talk to you later.
Okay. Bye
Bye.
bye.